Extradition is a very important topic, and it's also a very complicated one. Recently, it's been subject to really quite a lot of political controversy, and at the same time, the law itself has been evolving. And so it seemed a good moment, 10 years after the main piece of legislation, the Extradition Act of 2003, came onto the statute, to take an overview of the whole subject. As far as assurances are concerned, the government is carrying out a review, and we welcome that, and we look forward to seeing its conclusions. In addition, we feel that it would be in the wider public interest for what you might describe as a register to be kept of assurances, so that not only the government and the persons affected, but also NGOs and so on, will know what the position is, and appropriate monitoring can then take place. And then in the context of monitoring, we think it would be desirable that within the assurances given, specific thought is given to and mechanisms stipulated about how, in fact, the terms of these assurances can be properly and regularly monitored. We are extremely concerned about the way in which the government of late has been looking at legal aid, and we, like the Sir Scott Baker review, believe that a proper and full cost-benefit analysis should be carried out into whether or not legal aid is granted automatically in this context. We felt it was cursory, and it was really neither sufficient nor was it credible. And also we felt that in the last analysis, it's important that the interests of justice trump simply matters of housekeeping. And so we believe that if a full and proper cost-benefit analysis is carried out, the case has got to be made on financial grounds for not having it generally available rather than the other way around. We also concerned, and we had instances given to us of what seemed to be disproportionate way in which people who were being extradited were treated. For example, people being asked in America to provide bail, when in reality they were, in practical terms, often unable to do so. A number of examples were given to us from what happened in the United States. But I think it's terribly important to appreciate this is not an issue which is confined to the United States. Rather, it's a general issue which relates to all countries with which we have extradition arrangements. Because if you're extradited to stand trial, it's important to realize that you have not been found guilty, and therefore it's inappropriate simply to treat someone as a guilty prisoner. We concluded in an interim report that it was vital for this country that we continued to be part of the system. And it's important that we recognise that over the years there have been problems, but the system is evolving and is becoming much more fit for general purpose. In addition, we are anxious because there are a number of flanking measures surrounding the European arrest warrant, some of which we've opted back into and some of which we haven't. And we feel it's important that it's appreciated that the European arrest warrant is part of a much wider system surrounding extradition law and extradition, and that if we don't find a way of dealing with all aspects of this, the system we have in place will be less than completely fit for purpose. Well, as is normal for reports such as this, we have reported to the House of Lords, and it's for the benefit of parliamentarians, both in the Lords and the Commons, and also to the wider public and people looking at this. And we await a response from the government, which will be debated subsequently on the floor of the House. And I would like to think that the effect of the work we've done will be to bring about changes that will improve the country's extradition arrangements.